Welcome to the Berkeley Symposium on Same-Sex Marriage Law and Politics. This afternoon event is being co-sponsored by the UC Berkeley Institute of Governmental Studies, IGS, and the Institute for the Study of Social Change, ISSC. My name is Mark Levin, and I'm the Assistant Director of the Institute of Governmental Studies and the symposium's lead organizer. On behalf of both institutes, I am very pleased and honored to open this public event. We have gathered a very distinguished group of participants today who have agreed to come here in the spirit of academic freedom and open dialogue. Several participants have traveled across the country to be here and to be heard. Our topic today, same-sex marriage, is controversial, divisive, contentious, and emotional. Our panelists come from a broad spectrum of influential special interest organizations, academia, the professions, and public life. Taken together, these 12 participants represent the range of opinions and forces that are shaping this public policy debate. The origins of this symposium go back to November 2003. At that time, Bruce Kane, the IGS director, and I were walking into work one morning and discussing the breaking news out of Massachusetts concerning its state appellate court decisions on allowing same-sex marriage. Bruce said to me, "Mark, I believe this matter has the potential to be a major issue in the 2004 presidential election, and we should organize an academic gathering on this dispute." Well, Bruce, here we are 5 months later doing just what you suggested. Bruce, thank you for your inspiration, your insight, and instincts for allowing us to organize a public service activity for the university of this nature. The debate to define state-sanctioned marriage has touched off a political maelstrom across the country. We hope that today's program will serve to educate and explore this controversy. This program is within the Berkeley tradition of creating a forum for free speech and open exchange of ideas, no matter how passionate. I ask that the audience be respectful and civil during these proceedings, even if you personally disagree with statements you might hear today. Let UC Berkeley lead the way in creating open forums on the great issues confronting our society today. Today's event will consist of two parts. The first panel will be moderated by Professor Rachel Moran, Levin Professor of Law here at UC Berkeley. Her panel will explore the legal, constitutional, and public policy dimensions of this topic. The legal panel consists of 8 participants and will operate as a roundtable discussion. The second panel will be moderated by Professor Bruce Kane, Robson Professor of Political Science at UC Berkeley. His panel will address the politics surrounding this issue and will host 4 experts. If time permits, at the close of each panel, we will offer an audience participation segment. Under your chairs, you will find question cards. These are to be used if you want to pose a question during the question and answer session to participants. One of today's panelists, Professor Evan Gerstmann, in the preface of his new book on today's topic wrote, quote, "Same-sex marriage has become a front-burner issue in American constitutional law, and things are moving rapidly. The most interesting events are yet to come." With this sentiment, I hand the symposium over to Professor Moran. Thank you for joining us today.
Thank you very much. It's a pleasure to be here today. In this first panel, what we're going to do is begin with a 5-minute statement from each one of our panelists, and then we're going to pose a series of questions, any one of which they can be free to answer. I will introduce each panelist as he or she speaks. Let's begin with Carole Migden, who is the chair of the California Board of Equalization. Previously, she served in the State Assembly, where she authored legislation to create California's Domestic Partner Registry. Her public service also has included 5 years on the San Francisco Board of Supervisors, and currently she is a candidate for the State Senate.
Thank you. Thank you very much. I'm very pleased to be here with this group of academics and distinguished panelists, as political scientists, legal scholars. My mother would wonder what I'm doing here, but you'll tell her. You know, and here we are at Cal, which is the greatest public education institution in the world, and this august assemblage is convened to have an erudite discussion of same-sex marriage. I'll tell you, that's a victory in itself. And the fact that in America and throughout the globe today, people are debating same-sex marriage at their dinner tables regularly, that's a victory in itself. And in the brief time that I have apportioned to me, I want to make several points which I think attest to the timeliness and the inevitability of the acceptance of gay marriage. First of all, I'd like to say that America's families have been redefined, and gay families are just part of new and evolving family units in society today. Less than 25% of American households adhere to that old Ozzie and Harriet standard, and if I'm dating myself, excuse me, basically a traditional nuclear family. Look at our neighborhoods and our communities today. We have families headed by single parents, multi-ethnic parents, non-married parents, step-parents raising children from other relationships, grandparents raising kids, ethnic households which can be multi-generational, lesbian and gay parents, children who are born from artificial insemination or in vitro fertilization, a vast majority of couples adopting foreign-born children of different ethnicities often, and lesbians, particular lesbian households who have the heart and humanity and often adopt children that may have HIV or other diseases like fetal alcohol syndrome. My point is that lesbian and gay families are just one facet of a broader societal definition of family that's in evidence today. Gay families and other new families are being assimilated into a changing mainstream culture, step by step, every day. Half of the Americans polled recently in the New York Times said half support legalizing same-sex unions, and about 40% support lesbian and gay marriage. And as a long-time activist in the trenches, you start at 40%, ladies and gentlemen, that's not a bad place to start. That can only do better in time. And I believe the lesbian and gay community and our proponents are not losing but winning this fight. Again, you can't pick up the newspapers without reading about it, and there is sustaining coverage because there's interest. And we, the lesbian and gay community, is enjoying increasing acceptance. 7 out of 10 Americans report they know somebody gay or a lesbian, have a neighbor, have positive views. 65% of Americans, according to the LA Times, say lesbian and gay couples living together is okay. This is what's striking. Nearly 7 out of 10 young people, those under 30, support live and let live lesbian and gay marriage. Now you want to compare these attitudes to the 60s, the 50s, the 40s. All I can say is, do you recall in 1989 San Francisco rejected a statewide vote on domestic partnership? That was 1989. So we've come so far in actually a limited period of time. In 1997, when I served in the state legislature, I tried a domestic partnership bill 3 times, and finally it succeeded in 1999 domestic partner. That's 1999, it's 2004, but even that had to be curtailed to smooth its exceptions because it included retired workers, seniors, state workers. It wasn't a straight, flat-out domestic partner. It was a baby step towards recognition, and that was just a few years ago. Around the nation and globe, we see acts of defiance and lesbian and gay support all over. 4,000 marriages in San Francisco, in New Jersey, in Oregon, in New Mexico, all have performed same-sex marriages. Massachusetts is about to issue marriage licenses unless there's a court reversals. Officials in New York, Salt Lake City, Minneapolis, Chicago, Seattle have expressed support. In fact, Mayor Daley of Chicago was denied communion because of his support of gay marriage. That we read in the Los Angeles Times last week that certain heterosexual couples are forestalling their marriages until their lesbian and gay friends can get married too with equal rights. The new Prime Minister of Spain, what did he say? He spoke out in his first passage to Spaniards, to his people in his elected democracy. I support legalizing same-sex marriage here in Spain. That follows Canada, Belgium, the Netherlands, where, frankly, they regard the American upheaval about this, with bemusement. I also want to say that this marriage movement isn't just a political expression. I think it is broader, and it's igniting people's consciousness all over the nation and globe, and it is more cultural than political. The thousands of same-sex couples that stood outside San Francisco and braved the weather at City Hall were joyous. And they were there not because MoveOn.org had organized them. They were there for their own thriving and yearning for validation of their individual organic family units. And part of it was a deep-seated social need for affirmation that no political organizing to match, nothing that's spontaneous, genuine, loving, or extraordinary could have been composed merely through a political alignment. Please wrap up. They told me I had 7 minutes. Okay, well, all right. The views are kind of different. Madam Elected wraps up a little bit, but not quite. So let's see where we are. We should have timed it. Religious marriage you're going to hear about, and I guess what I'd like to say is the seeking out lesbian and gay marriage is a civil right. We're looking for the state to grant marriage a license to marry, not differently than one seeks a professional license, not differently than one seeks a driver's license. There's certain criteria set forward. The government, we believe, has a responsibility to grant civil unions to consenting adults wholly and apart from religious considerations. That's a separate track, that's a private track, that's a personal prerogative with regard to one's religious training or belief. It's fine with me if certain religious communities curtail whatever they believe has to fit in order to accommodate their beliefs, but that's wholly and that's separately apart from the right to a civil union. So what we're seeking here is not separate but equal. What we're seeking here is full acceptance of a civil right that each American in our open society is entitled to, and we want very much to separate that discussion and not commingle it with issues of religion. And let me just say that a recent poll, and I know you'll hear from some individuals to the contrary, but 35% of conservatives in California now support civil unions, and 36% of residents of San Bernardino County, California, 36% say okay on gay marriage today. And I say that just speaks to the inevitability, and I believe within 10 years from today, we will have a legal institution, and this will be a non-issue for our academic discussions. Thank you.
Our next speaker is Alan Chambers. He is the Executive Director of Exodus International, which is based in Orlando, Florida. Exodus is a global network of agencies and ministries, quote, proclaiming to, educating, and impacting the world with the biblical truth that freedom from homosexuality is possible, end quote. Mr. Chambers writes extensively and speaks nationally and internationally on issues surrounding homosexuality.
Thank you. My name is Alan Chambers. I am a Christian. I am a husband to my wife, Leslie, and I used to be a homosexual. To be clear, I did not choose my same-sex attractions, nor did I willfully adopt a homosexual orientation. But my response to both, my behaviors, were a choice. I remember being a lonely 18-year-old searching for Mr. Right. I remember the ache to have a man hold me, to protect me, to love me, and to devote his life to me. I remember thinking I'd do anything for that insatiable need. I did everything short of praying for my knight in shining armor to show upon my doorstep. I was certain beyond a shadow of a doubt that the missing piece to my life's puzzle would be found in a man. Nearly 14 years later, I am happy, content, satisfied emotionally, physically, spiritually, sexually, and relationally. My process was one of self-determination and willful choice to move beyond the box that I believe enslaves so many wonderful same-sex attracted people today. Change is possible, and I am living proof. I used to be a homosexual, and today I'm not. Had same-sex marriage been legal in 1990, I am certain that I would have tested that option. I met men whom I wanted to marry, yet today as a mature adult with a sober perspective, I realized that I wasn't searching for a man as much as I was searching for an answer, a drug to numb the pain, something to make me feel better about who I was. The law kept me from making one, if not many, life-altering mistakes. Recently, Dennis Teddy of the Weekly Standard said, "Government's purpose is not to dispense rights, but to secure rights created by nature and nature's God." The current laws saved my life and continue to save the lives of other young people like me who need life-saving boundaries. As a former homosexual, I know that this battle has little, if nothing, to do with marriage, but rather with an absolute need for social approval and acceptance. This experiment with marriage, being promoted by a few, is about silencing inward guilt, pain, and the gut-wrenching reality resident within many homosexual and lesbian people that their desires will never be completely satisfied the way they seek them homosexually. Legal endorsement and approval of same-sex marriage will simply guarantee that more lives of those today and future children will be ruined. We already live in a truly tolerant society where the law views us all equally. Neither race, nor religion, nor gender, nor age, nor disabilities can affect our personal freedoms. Our laws are created to protect the innocent. The laws in place that protect marriage do so to protect the institution that has been the bedrock of society for thousands of years, and most importantly, to protect children. A two-parent, one-man, one-woman family is the best environment in which to raise the next generation. We must do all we can to protect the family unit. Again, I am one of tens of thousands of people who have successfully changed their sexual orientation. I'm grateful for the message of change, and I'm grateful for the laws that saved my life. Thank you.
Our next speaker is Evan Gerstmann. He's an associate professor of political science at Loyola Marymount University in Los Angeles. He is author of the recent book entitled Same-Sex Marriage and the Constitution, published in 2003, and a previous book entitled The Constitutional Underclass, Gays, Lesbians, and the Failure of Class-Based Equal Protection, published in 1999. He is a frequent commentator in the electronic and print media.
Thank you. Good afternoon. Thank you to all of you for coming out this afternoon to hear us. Because this panel is set up as supposing to focus on the law and the next panel on politics, I think I want to begin with a question many people ask about the law and same-sex marriage, which is, why are the courts involved in this at all? We're a democratic society. Why shouldn't people be voting on this? Some people of good faith who are disturbed at what's happening say this should be done democratically, not be done by the courts. I want to begin by addressing that issue. In any democratic society, there's always a tension between two important concepts: majority rule and minority rights. We are a democratic society, and that should mean something. That should mean that usually the majority gets its way. If the majority wants a certain person to be president, if the majority wants certain kind of Social Security legislation, that's the way it should be. And yet at the same time, the majority can't simply do anything to the minority that it wants to do. And so we've come to a compromise. The way we try to resolve this great constitutional tension to majority rights, between majority rule and minority rights, is to say that in the great majority of situations, it's majority rules. But in certain fundamental areas of human autonomy, the minority has to have equal rights with the majority. Marriage is a perfect example of the latter category. The Supreme Court has long held that marriage is one of the fundamental rights of human beings. They've held this over and over and over again. People often say to me, do you think James Madison and the other founding fathers were really thinking about same-sex marriage? And that's generally a hostile question because obviously they were not. And I always say, well, no. Of course Madison was not thinking about same-sex marriage. But he and his fellow founders were certainly thinking about tyranny of the majority. Look at the current situation. Marriage is in a lot of trouble in this country in many ways, with very high divorce rates, even when children are involved. And what is the heterosexual majority doing about that? They're showing no stomach at all for restricting their own freedom to marry and divorce at will, even when children are involved. It is so easy for the heterosexual majority to fail to restrict their own absolute freedom to marry and divorce at will, but then point their finger at a small and relatively powerless minority and say, we are the protectors of marriage against you. And I think that's the sort of political dynamic that Madison and the other founders were very much concerned about. It's simply too late in the day to argue that same-sex marriage is not a fundamental right. The court has held this in so many different ways. Prisoners have the right to get married, even when still serving their prison sentences. Men who fail to support their children from previous marriages have been held to have a fundamental right to marry. Well, what does that mean? It doesn't mean you can marry anybody or anything you want. All rights have limits. I have freedom to speech, but I can't say things that are obscene. I can't commit perjury. So there are limits. But the fact that marriage is a fundamental right means that it cannot be denied to gays and lesbians without the government articulating strong, rational reasons for excluding them. And one of the problems the anti-same-sex marriage movement has had, and I think this is the reason why there's been such rapid movement, is they've had remarkable trouble articulating why gays and lesbians should not be married. It certainly can't be because of children. Right? I mean, 80-year-olds get married, and people think that it's charming. Nobody says you can't get married when you're 80 because you can't have children, so obviously we can't say that to gay and lesbian couples as well. All of the other reasons quickly fall under analytic scrutiny. It's remarkably difficult. So to me, this is really a question not about what do you think about gays and lesbians or homosexuality. It's simply a question of equal rights for everybody. People will often say to me, well, what about polygamy? And I think that's a question a lot of people have on their minds. And I always welcome that question because it gets to the heart of the debate. This is a debate about equal rights for everybody. Would-be polygamists are seeking a right that nobody else has, the right to marry as many people as they want. Gays and lesbians are just seeking the same right that everyone else already has, the right to marry the person they love above all others. It's funny to find myself here defending same-sex marriage in the middle of this controversy. My friends are often surprised to find out in many ways I'm quite politically conservative. I often say I have a liberal head and a conservative heart. I think that marriage is a beautiful, important institution that does need to be protected. But the way to protect it is not to keep loving adults who want to marry, who are interested in commitment, responsibility, love, out of the institution of marriage. I hear people talking about getting government out of marriage altogether and only having civil unions and leaving it to the church to marry people, which strikes me as burning down the house to keep gays and lesbians out. The fact is, same-sex marriage will produce a much less radical change in marriage than, say, the movement towards women's equality has. There is no single definition of marriage, which is now being altered. Marriage has changed enormously over the years. The full legal equality for women has had a much, much greater change than this will. This is nothing more than another small incremental change in marriage to make it inclusive to a group of people who have been arbitrarily locked out. Thank you very much.
Our next speaker is Teresa Stanton Collett, who is a professor of law at the University of St. Thomas School of Law in Minneapolis, Minnesota. She testified recently before the United States Senate Judiciary Committee in favor of the federal marriage amendment. She also filed an amicus brief before the United States Supreme Court in Lawrence versus Texas, which a case involving Texas's anti-sodomy law, and she also filed a brief supporting the state of Massachusetts in Goodrich versus the Department of Public Health.
Good afternoon. First, I'd like to compliment the organizers of this conference for its attempt to create balance on a debate of great social significance and great emotional content. So often these conversations are engaged primarily in preaching to the choir. Those on my side of this debate talk to people who are absolutely opposed to any recognition of same-sex unions, and people on the other side of the debate talk to those who are absolutely committed to same-sex marriage, and there's not much conversation between the two groups at all. And it's incredibly important when we're talking about matters of such important political import that both sides have an opportunity to hear that conversation dealt with by people that have some level of conversance at the level that we're going to have today. So I think this is a wonderful opportunity, and thank you very much for allowing me to be a part of it. Let me begin by saying that the first speaker, Carole, and I have at least one point of agreement, and that is what is at issue today is the question of civil marriage. What is not at issue is the sacrament of marriage or religious marriage. I think that that question should not be one that we are here to debate, and not an issue that really should be a question of state control. And she made what I think is a very important point, which is what should be the heart and core of our conversation is what are the criteria that government has traditionally used in looking at whether or not two individuals are entitled to be licensed to marry in the state. And so when we hear individuals argue that same-sex couples should be either included in marriage or excluded from marriage, I think we have to look at what is the purpose of civil marriage and what does the state look at for purposes of issuing a marriage license. And historically in the United States, it has always required that there be a man and a woman. But more importantly, when that man and woman received that marriage license could always be declared void if they did not engage in one simple act. That act was not moving in together. That act was not establishing a joint bank account. That act was not entering into joint contracts. That act was engaging in the act of sexual intercourse. Why was the state interested in whether or not a man and a woman had engaged in the act of sexual intercourse, the one act that no gay or lesbian couple is capable of engaging in? Because the civil institution of marriage is about channeling one man and one woman into a permanent monogamous relationship, because through that act they run a fairly substantial risk of creating a new life. And in the creation of new life, we want to ensure that the man who has participated in that act participates in the nurturing of that new life to adulthood. A problem that we continue to experience. Notice the tremendous difficulty we have in ensuring that deadbeat dads pay child support. Notice the large increase we have had since we've instituted no-fault divorce, with the increase of single moms and children in poverty. So in fact, the civil institution of marriage is not about adult commitments, not about issuing love licenses, if you will. It is about channeling that procreative act into a permanent monogamous relationship. Now, the question was posed by Professor Gerstmann, well, then why do we allow 80-year-olds to marry, although males may indeed still be capable of procreation, but females surely aren't, unless, of course, we're dealing with Sarah or other historical figures. But nonetheless, as a general rule, one might reasonably presume that we need not worry too much about procreation at that age. But the fact is, what we want to do is we want the model for young men and young women to be that a man and a woman who are going to engage in this conduct will enter into a permanent monogamous relationship before they enter into that conduct. Why do we want that model throughout society? Because we know the consequences of them not entering into a permanent monogamous relationship. We know the consequences of fatherless children are not good. We know that those children will have less economic security, less psychological security, and their academic progress will not be nearly as good. That's not to say that there are not single mothers out there through their own heroic efforts achieving unbelievable results, but that is not the model that we want to see. If in fact we continue to expand marriage to include same-sex unions, we are saying marriage is about adult commitments. It is not about ensuring the well-being of children. That is a fatal mistake. Thank you.
Now we're going to hear from Kate Kendell, who is Executive Director of the National Center for Lesbian Rights based in San Francisco, and previously was their legal director. The center is a, quote, progressive, feminist, multicultural legal center devoted to advancing the rights and safety of lesbians and their families and to doing legal advocacy and policy work on behalf of all LGBT individuals.
Thank you. Thank you. I'm very happy to be here. And unlike many people on the panel who came a long way, I'll be home in 40 minutes. So many of us, no matter where we were in the country, woke up on the morning of February 13th and saw this picture in the newspaper. Any questions? Del Martin and Phyllis Lyon were the first lesbian or gay couple, for that matter, to marry in this country. They had been together the day they got married, one day shy of 51 years that they were celebrating. And that day, I mean, this picture also, it's not my most flattering picture, but me in the background sobbing. Sobbing because I understood how emotionally profound it was that after 51 years together, Del Martin and Phyllis Lyon had the one thing they'd never had, the dignity, the human dignity of government respect and acknowledgement of the commitment that they had made to each other and continue to make to each other. That profound message was repeated again and again and again, and I could do that over and over again and take all my 5 minutes, 4,000 plus times. And those images of couples standing in line beamed around this country and on the nightly news, night after night after night, images of couples joyfully, publicly making that commitment to care for each other's welfare profoundly shifted the ground. February 12th, the date that the first licenses were issued, culminated a spectacular decision by San Francisco Mayor Gavin Newsom to use his authority, as I will say mayors and governors have done in the past in this country, to ignore a state law that he believed denied citizens equal protection of the law, and to abide by a higher authority, the constitutional authority, and the aspirations of the California Constitution to accord to all lesbian and gay couples the same kind of equal protection and recognition that every other couple gets to take for granted. The issue of permitting lesbian and gay couples the same equal rights to marry is, from my view, just as much an economic justice issue as it is a civil rights issue or an issue of fundamental rights. And one thing that those lines did not capture, at least in terms of the media images that I saw when I was traveling and saw the images nationally, is they did not capture the full diversity of those couples who were standing in line. White couples, of course, biracial couples, African American couples, Asian couples, Latino and Latina couples, many, many of them with children, and many, many of them having been together for dozens of years. Those couples have survived, whether it's 51 years or 5 years, without government protection and support. And we see the cases every day of the havoc that is wreaked on couples and children because the government denies this very basic and fundamental protection. Couples where a partner dies and there's no Social Security survivors benefits for the partner or their children if the deceased partner was not able to adopt. Now, if you don't think that's an issue that affects children's welfare, look at what Social Security survivors benefits provide in families where they're provided. They're the safety net. And so many of the federal and state protections that go along with marriage are about supporting and strengthening and making more muscular the commitment of one person to another through the kind of security, economic protections, and cultural acceptance that marriage provides that has always been denied to lesbian and gay couples. We know the difference it would make in the lives of these children and in the lives of these couples to have those kinds of protections and security. And I also believe that the arc of history and the arc of this history is tracking in the direction of full embracement and celebration of these relationships and these families. I do believe it is inevitable that equal marriage rights will exist in this country for lesbian and gay couples, and not because of people like me in legal organizations who are fighting these cases as we are in California, or other lawyers who have done it around the country, or activists who have been making their life's work doing this kind of work. It's because average folk sitting in the middle of America saw this picture or those images and for the first time engaged in a vigorous discourse in their own mind and with people that they love and care about. And it is those folks who are going to make the difference in how this last chapter of this fight is written. Thank you.
Our next speaker is Roger J. Magnuson. He's the Dean of Oak Brook College of Law and Government Policy, which is a distance learning institution of Christian legal education with its office in Fresno, California. In 1994, he published a book entitled Informed Answers to Gay Rights Questions. A practicing attorney in the areas of business and commercial litigation, he also speaks widely on legal and social issues.
Well, thank you very much. I come with an accolade, an analysis, and an argument in that order. I think the accolade is probably the most shocking thing I will say because my prior experiences at Berkeley have been generally as a Stanford jihadi coming up the Bayshore in an effort to slay the golden bear, who still curses the Stanford band for reasons all of you should be aware of who know something about Berkeley. But I just want to add my voice to the others on the panel and just celebrate the Institute of Governmental Studies and Mark and others who have given wonderful treatment to me and wonderful treatment to this issue. I think Perhaps under the accolade theme, we can all agree that too much of the discussion of this issue has been ad hominem. And while people on both sides of this issue can give their own examples, I think this is not about bigotry. It's not about homophobia or homophobia-phobia. There are serious issues that need to be addressed here by public policy makers and people interested in the law. Secondly, there's too much argument by anecdote, and with due tribute to the very articulate presentation of Ms. Kendell, this issue is not decided by pictures in the newspaper or having a nephew or having very sympathetic treatments of people who do share romantic love for one another. It goes beyond anecdote. And frankly, there's too much argument by assuming the conclusion, the old question-begging fallacy. The issue here is not whether a right is being infringed, but whether a new and fundamental right ought to be created. One doesn't have to be an Austinian legal positivist to say that the positive law is what the positive law is. Currently, homosexuals do not have the right to marry. The question is whether society wants to take the steps of adding that right to the current positive laws and rights that exist. So first of all, the accolade. Thank you very much. It's a great pleasure to be here. Secondly, the analysis. I think we have to agree on at least three things here. At least I would suggest three things. Number one, this is a radical change. We have thousands of years of experience of various religious traditions and various social arrangements, and this is a radical change from current rules of the road that have millennia of both moral and legal tradition behind them. That's not to say that radical changes aren't sometimes necessary, but it makes very clear that, as we trial lawyers like to say, they've got the burden of proof, because this is a radical change in social arrangements. Secondly, it's not only radical, but risky, because when one does transform radically social arrangements, traditional arrangements, there's always the peril of unintended consequences. So we ought to be cautious about this. The Romans, for example, as Henry Maine points out in Ancient Law, transformed their one marriage into three different kinds of marriage, the last of which was something approaching a domestic partner law called the law of connubium. And this resulted in the temporary deposit of a person with another person. Both Henry Maine and Gibbon, in his Decline and Fall of the Roman Empire, blamed the dilution of the family bond as one of the significant disintegrating factors in the decline of Rome. It's radical, it's risky, and third, it's rationally suspect. We have here a behavior that deviates from the norm. We have probably 2% of the population, maybe 1.5 to 2.5% of the population that engages in certain forms of same-sex attachment. It's not only a departure from the norm in terms of its statistical significance, but also in terms of its substantive significance. As Dr. Armin Nicolai said, prior head of the psychiatry faculty at Harvard, simulating eating is not eating, simulating being a man is not being a man, simulating being a woman is not being a woman. And this is, as Dr. Socarides said of the Einstein School of Columbia, a masquerade. It's a different form of sexual expression. Now, when we have a deviant form of behavior, we have to determine what to do with it as matters of public policy. There's three things we can do with it. We can prohibit it, and that was the case at the time of the framing of the Constitution, where every colony, ultimately every state, had a law against what they called the crime against nature. Secondly, we can tolerate it, and after Lawrence, that's the official position of the Supreme Court of the United States, that all attempts to criminalize sodomy must fall, and we can have a laissez-faire environment. Whatever you do in the context of your own bedroom is fine. Or you can give it special privileges or special protections or special dignity in the eyes of the law. That's what we're talking about here. And when we look at this, we have to look very clearly at both the group and the behaviors that characterize the group. And as talented, as fun as many of my homosexual friends may be, we have to look dispassionately at the characteristics of this group. First, in concept. The concept of marriage, as Professor Collett so well put it, is to create a stable matrix for procreation and the rearing of children, with an emphasis on the ideal of monogamy. Many of my homosexual friends on this issue say, yes, we want monogamy without fidelity. The whole ethos of the homosexual movement, as we see from some of the statistics, is promiscuous rather than monogamous. And indeed, the experiences of people of other states that have tried homosexual marriage have not suggested that the promiscuity has diminished. Secondly, the complementarity of men and women are implicated. Plumbers and electricians know the male and the female, and there's a complementarity that's not only physical but psychological and emotional that creates the best place to nurture children. Homosexual relationships do not have that complementarity. As Dr. Sakarides said, they're a masquerade of life. And third, the characteristics of the group, as much as one is sympathetic with the people who are engaged in these practices, is very disconcerting. As the Atlantic Monthly said not so long ago, it appears that 2% of the population has over 50% of the venereal disease. Statistics on promiscuity and shortened lifespans and other things make this a very real concern for the homosexual themselves. So I would suggest it's risky, it's rationally suspect, and it's radical. Finally, just an argument. I think based on what we know, as Professor Collett has so well put, about the benefits of marriage, what we ought to be talking about is not diluting marriage or opening marriage to other forms of sexual behaviors, but we ought to encourage marriage. That is to say, you tax what you want less of, you subsidize what you want more of. I think based on impoverization of children from divorce and the other bad consequences of marriage that's disintegrating in this country, we ought to encourage people to get married heterosexually and stay married heterosexually, and we ought to incentivize that and put more clear blue water between heterosexual marriages and other forms of social arrangements, whether cohabiting or homosexual marriage. That's my modest argument for today. Thank you.
Okay, our next speaker is Andrew Koppelman, who is Professor of Law and Political Science at Northwestern University. He has written The Gay Rights Question in Contemporary American Law, published in 2002, and Anti-Discrimination Law and Social Equality, published in 1996, which won a Gustavus Myers Center Prize for outstanding work on intolerance in North America. His current research focuses on the legal enforcement of morals.
Thanks. So, 5 minutes I've got to tell you everything there is to say about same-sex marriage? I don't think so. There's too much to talk about there. So I'm going to start by talking about what I'm not going to talk about. I'm not going to talk about the constitutional arguments. I am not going to talk about the natural law argument that marriage is inherently heterosexual. I'm not going to talk about the issues of conflicts of laws that are raised when one state recognizes same-sex marriage and the validity of that marriage comes up in another state. I've got a book. It's over 150 pages long. I go through all of that stuff. It seemed to me that given that we're trying to have a dialogue about this issue, and since concern on the other side of the aisle that has come up again and again is the question raised by Professor Collett as to what's the purpose of marriage, or Professor Magnuson talked about the concept of marriage. It seemed to me that it's incumbent on people like me who support same-sex marriage to explain what kind of thing we think marriage is, because this is something that the other side has pressed us on, and it seems to me that it's incumbent on us to provide a response. I had a debate in print with John Finnis a while ago, who's one of the most distinguished philosophers who opposes same-sex marriage, and he observed that the idea of same-sex marriage corresponds to no intrinsic reason or set of reasons at all. And so it seems to me that folks on my side need to say something in response to this. What kind of thing do I think marriage is? Does something like monogamy make any sense in terms of the kind of concept of marriage that includes same-sex marriage? So let me try to say a little bit, just say something about that. Now, it's common ground between us that marriage is a traditional practice that realizes ends that are intrinsically good. There are others who think that marriage is not such a hot idea at all, but we'll have to engage with those in another place. The issue is whether those goods can be realized equally well outside of the tradition of solely heterosexual marriage. My claim is that marriage is not a timeless essence. It's a historical, cultural formation. And so the question shouldn't be whether the practice corresponds to a metaphysical reality, but whether the goods that have traditionally been recognized when all went well in that practice, didn't always go well, can also be realized in other social units that don't correspond to the traditional definition. I think the way to think about this is a proposal to modify marriage is ontologically similar to a proposal to modify the game of chess. Chess doesn't correspond to any intrinsic reasons or set of reasons at all. So consider someone proposes, I want to change the rules of chess so that the rook can now move diagonally one space, in addition to all the other moves it can already make. Well, you'll say if we adopt that rule, we aren't going to be playing chess anymore. We're playing some other game. And this kind of argument has been made about actual games. When the designated hitter rule was introduced in baseball, the strongest objection that was raised against it was, that's not baseball. And that really resonated with some people. Now, it seems to me that in each case, the question is whether this transformation is going to make the game a better game than the one we play now. And I don't think you can resolve that question by trying to figure out what the essence of chess is. Chess hasn't got an essence. I presume, it seems pretty clear to me just looking at the game that the knight was a late addition to the game. It doesn't have it has a different logic than any of the other pieces, but it's a better game with the knight than without the knight. So the question about same-sex marriage is, if we take a look at the goods that are presently realized by marriage, the connections between adults, the creating of stable households where children can thrive, is it the case that those goods can be realized by same-sex couples? And here it seems to me that the evidence is fairly massive, given the big social transformation has already taken place. There already are same-sex households, whatever you want to call them and whether the law wants to recognize them or not. And I can only summarize here a fairly already large body of evidence that those goods are in fact being realized by the same-sex couples that are already in existence. And so the question about same-sex marriage is just, is it able to realize those? I think the answer has already been answered in the affirmative. There's a last point about the consequences of recognizing same-sex marriage. Because a second argument that was made is that, well, if you adopt this conception of marriage without an essence, bad consequences will follow. Bad consequences for children, bad consequences for adults. Maggie Gallagher recently wrote that same-sex marriage affirms that children do not need mothers and fathers and that marriage has nothing to do with babies. And so she claims that if the state endorses this message, there will be an increase in poverty and trauma caused by widespread fatherlessness. And a couple of our panelists have made the same point. I don't think there's any way to disprove this kind of claim in which the causal chain runs through the unobservable consciousnesses of millions of people, but I don't see that there's much reason to believe it either. You need to show how recognition of same-sex marriage is going to affect any father's deliberations about whether to stay with his children. So Stanley Kurtz, who makes essentially the same argument as Gallagher, writes that the association between marriage and parenthood is partly a mystique. Men apparently need to be mystified in a certain way in order to get them to stay with their children. But this seems to me to be unduly pessimistic. I have 3 kids myself. Do you really think that I stick around because I'm mystified and confused?
I think everyone's mystified and confused about whether that's the end of your remarks. Okay, our final speaker is Jeffrey J. Ventrella, who is the Senior Vice President of Strategic Training for the Alliance Defense Fund, which does legal defense and advocacy of, quote, religious freedom, the sanctity of human life, and traditional family values, end quote. He also teaches ethics and apologetics at Greenville Presbyterian Theological Seminary and Bonson Theological Seminary.
Thank you very much. I just want to echo the gratitude that I've sensed and seen now demonstrated by the producers of this event. It's been a very balanced situation, been treated well, and I want to thank you for it. We're not here today to talk about checkmates. We're here to talk about same-sex mates, and I'm going to begin empirically. We've seen dedicated, well-organized, sincere activists appeal to the courts of this land, attempting to reconfigure the very essence, the very structure of marriage, claiming that there's been a denial to marry the person we love. That's good rhetoric, but that's bad law. Now, I'm not talking about what's happening in Massachusetts or San Francisco or any other place. I'm talking about what we've seen in our American jurisprudence dealing with Utah trying to receive statehood. The polygamy battles had the same sort of issues that went on and on and on. And what was the essence of those legal debates? The essence of those legal debates constitutionally was, can we have legal recognition of a different structure of marriage, a structure that disavows one man, one woman in monogamy, so on and so forth. The Supreme Court said no. The Supreme Court recognized both the communitarian benefits to society that one man and one woman living in monogamy confer, as well as the complementary design of a male and female, as opposed to an androgynous Mr. Potato Head view of human relations. And what the court said was, marriage is, quote, the union for life of one man and one woman, which is, quote, the sure foundation of all that is stable and noble in our civilization. And so what we need to understand contextually here is, this is not a new issue. This is not a cutting-edge issue. It's not cutting edge in American jurisprudence, nor is it cutting edge in Western legal tradition. And every time there has been legal reformation that's occurred, it's always occurred with respect to tweaking the fundamental structure, one man and one woman. Never has it been obliterated. But same-sex marriage seeks to change the structure, just as the activists 150 years ago attempted to change that structure. And so we've got to do better. We've got to look at this issue dispassionately. We need to have arguments, not quarrels, but arguments, not anecdotes. This is not the forum, and this is not the issue for fallacious reasoning, going from is to ought, for example. David Hume told us about that one. The fact that there happen to be same-sex families and same-sex relationships doesn't prove that we ought to have recognized in our society same-sex marriage. This is not the place for loaded slogans. I'm grateful for that. That's not happening here. What I like to call bumper sticker jurisprudence. Equality, due process, fairness, without any real boring down analysis. This is not the time for arbitrary assertions or emotional appeals or equivocation. Rather, it's the time to roll up our sleeves and look at marriage. Again, what this court said was the sure and noble foundation of this civilization. Now, as we come to this, we'll see then that Lawrence versus Texas, though I believe it was wrongly decided, and though I believe it's poorly reasoned, nonetheless, on its face, militates against same-sex marriage. And it does so even on the due process question. Because on the due process analysis, the jurisprudence of our courts have held, you have to have an asserted right that is, what, objectively and deeply rooted in this nation's history and tradition. That comes from the Glucksberg decision, which I believe deals with the ultimate, private, intimate decision, assisted suicide. And there the court said, no, we're not going to allow people, even if they're willing, even if they consent, to kill one another. That's a private context. How much more does that rationale apply then when we're dealing with not with just private choices, but when we're dealing with a public institution of marriage? And so I concur, this is a radical idea, though it's not new. And it is a risky idea. And I think you'll find that there's many risks, and we'll get to the sociological issues a little bit later. The reality is, advocating same-sex marriage is like telling a geometry teacher to draw a square circle. You can believe it passionately, but you'll never be able to draw a square circle. Thank you.
What I I wanted to do now was to follow up on some of the issues that came up during the presentations and then raise a few new issues that the panelists did not have the opportunity to address. First of all, we heard a number of comments about the purpose of marriage and whether marriage is a fundamental right. What are the sort of historical purposes of marriage, and why is marriage a fundamental right in light of those purposes? Anybody? What makes marriage a fundamental right? For those of us who aren't lawyers who are in the audience, why is marriage a fundamental right, and how does that bear on this debate?
There's a number of different levels you can answer that question on. One is the legal answer. The marriage is a fundamental right because the Supreme Court has long since held it's a fundamental right. I think somebody spoke about the burden of proof should be on those who favor same-sex marriage. But in fact, the opposite is true. When the court holds something's a fundamental right, that means the burden is on those who would exclude others from enjoying that right. I would also say that marriage is a fundamental right because, like other fundamental rights, it goes to freedom of association, freedom of expression, it goes to fundamental areas of human autonomy. The government ought not tell us who we can marry without some very, very good reasons. And I would argue that although heartfelt and sincere on those who oppose same-sex marriage, they really, other than very vague notions of complementarity, or very speculative arguments about how same-sex marriage will cause heterosexual men not to be faithful to their children, that burden simply hasn't been met.
Well, I think we have to be careful again about question begging the fact that there is a fundamental right to marry, and there's been held to be a fundamental right to marry. It doesn't mean you have a right to marry your sister. It doesn't mean that you have a right to marry polygamously, because marriage does have a conventional legal definition. And in fact, one could envision not simply the polygamous slippery slope, but one could imagine some bisexual in Berkeley feeling that his authenticity required him to have simultaneous allegiances to both a man and woman in his relationship. Might argue that he has a fundamental right to marry. The question is, yes, but he does not have at this point in time a fundamental right to marry a man and a woman in a threesome. And so therefore the fundamental right to marry loads into that what a marriage really is under the eyes of the law and what I believe it should remain.
What are the state interests that justify limiting that fundamental right to marry? You've given some examples where the state prohibits a choice about a partner. What are the reasons for limiting people's choices, and how do they bear on the question of same-sex marriage?
I think we wanted to correct the record.
Okay.
A little bit.
Feel free.
Well, this has been responded to, so but I suppose it's worth responding to again since it's brought up again. The issue of polygamy and then trot out the whole slippery slope parade of horribles happens over and over again, and with all due respect, it's the high art of question begging. What we're talking about here, we're not changing the numbers of people who can marry. We're not changing that fundamental structure on which not only the relationship is based, but commerce is based. I'm from Utah originally and was raised Mormon. I know a thing or two about polygamy, and it's an entirely different debate than talking about providing to lesbian and gay couples the same fundamental right that other dual couples enjoy. And you start with polygamy, and you can use all sorts of other scenarios, but it's a different argument, and it's a different structure, and it's a different debate.
Well, in fact, there has been no federal court that has found a fundamental right to same-sex marriage, although it was presented to several federal courts. Every federal court that's been presented that question has rejected it. The only success has been in the state courts. There are now 23 states that have had to defend their marriage laws, either previously or presently. And it's only after Lawrence that we've seen this massive acceleration. But there is no federal fundamental right to same-sex marriage. Every federal court that has been presented that argument has rejected it soundly, and they've rejected it on the basis that the fundamental right to marriage is grounded in the idea that marriage is about channeling procreation. And the fundamental fact is that same-sex unions have no biological potential through their sexual acts of resulting in procreation. It is true that there are some same-sex couples that are raising children, but there are also some adult siblings that are raising children. Are you therefore in favor of arguing that we should do away with the marriage ban on incest, where an older brother and older sister are raising their younger siblings?
I'd like to respond to that, obviously. The Supreme Court has held over and over again that there are certain reasons for getting married. Never once, at least not in the modern era, has it said it is solely for raising children. In a case called Bowers versus Hardwick, the court put its imprimatur on arbitrarily denying to gays and lesbians the same fundamental rights that others have. As long as Bowers was in place, it would have been impossible for a lower federal court to find a right to same-sex marriage. Bowers has now been overruled by a court that admitted that its historical reasoning was fallacious, that its legal reasoning was fallacious. So there's a whole new legal regime, but the idea that marriage is a fundamental right is quite old. It's as old as fundamental rights itself.
But
the court has now, if I can just finish the train of thought. Okay, with Bowers gone, the major legal obstacle to same-sex marriage being recognized as part of that fundamental right is now gone as well. So, I mean, your point is perfectly true. No federal court had recognized that. But that's because Bowers prevented it. Bowers is now gone.
But Bowers was overruled in Lawrence versus Texas in the same majority that overruled Bowers versus Hardwick. The court that overruled Bowers versus Hardwick.
You've said nothing before.
Please, let's just not talk over each other. We'll move to the next one in a minute.
You know, I just want to say, these folks here are talking about promiscuity and talk about no anecdotal evidence and gays want faithfulness or not. If we're going to kind of stick to some rules here, every time there's an answer being offered over here, it has to do with the nature of gay lifestyle or other kinds of prejudicial information interjected into the discussion. And it's wholly inappropriate.
The court in Bowers versus Hardwick.
Oh, we're going to hear this again? Okay, we got that. We all heard it. We got it. We know that. We know what you're coming from. Can we just move on?
Let's let her answer about the law, and then we'll move.
You guys stacked up this room. Yeah, you did. Well, I don't need to talk to you. No. Can we have another question?
Can we hear the speaker, please?
Let's give her a minute to wrap up, and then we'll move to the next question, okay? Okay.
Bowers versus Hardwick was overruled in Lawrence v. Texas, and in Lawrence v. Texas, the majority clearly said that it did not reach the question of same-sex marriage, and so we don't still have a federal court that has said that it supports that.
Yeah, and I understand that. Let me just make one final point, because I don't want it, for folks who are not lawyers in the audience, I don't want you left with the impression that there's anything unique about states being more protective than the federal government. Often state constitutions, the federal constitution creates a floor, and rights cannot fall below that. But state constitutions have traditionally, on a number of issues and a number of civil rights battles, been more protective than the federal constitution. So it is not at all surprising that state constitutions and state courts interpreting those constitutions would be leading the way in terms of being more protective of lesbian and gay relationships. There's nothing unusual about that.
And now, what I wanted to do is follow up on that, because normally people think of marriage as a state issue. These states issue the marriage licenses. A lot of the laws about marriage are at the state level. So why isn't this primarily an issue for the states to decide on a case-by-case basis, to experiment as they wish under a federalist system? Is there a reason for the federal courts to be speaking to this, or for it to be a national issue?
Well, I mean, if I could really quickly, okay. I mean, I think that, part of the problem is when you're dealing with an issue like marriage, it's very difficult to have that decided on a state-by-state basis. I mean, that's the problem with civil unions. Civil unions are terrific, and Carole Migden, when she was an assembly member, did yeoman's work in setting up a registry in California beginning January 1, 2005. There will be a very vigorous domestic partner bill that has been signed into law and will become law. You've got civil unions in Vermont. But as soon as my car with my partner and our children rolls across the border between California and any other border state, we are strangers under the law, and that's the way it is for any couple that's gotten a civil union. The other thing to point out, and while I would never make any easy analogies between this civil rights struggle and human rights struggle and prior civil rights struggle, it is important to note that if you leave it to states, then you're not talking about one nation under God or one nation united by a constitution. You're allowing individual states, and you're allowing the geographic discrimination to determine whether or not, suppose someone living in one state has protections and rights and security and recognition and dignity, and then they live in another state and they don't have any of that. I think it is important that this be determined as a matter ultimately of federal law, because it is marriage. We do go from state to state. We are one nation, and we do have a federal constitution that I believe should and will ultimately find these relationships recognized and protected.
I think with respect to the there's a distinction in my mind between a federal definition of marriage, which applies uniformly, versus federal regulation of marriage in the details. And what we have with respect to the Mormon polygamist situation, 50 years of litigation, we had the federal courts, the United States Supreme Court in particular, deal with the definition of the structure of marriage, again affirming that structure of one man, one woman living monogamously. That's distinct from then reserving to the states the ability to have the regulation of marriage in issues of the other components of marriage, such as capacity, such as age of consent, such as grounds for divorcement, and so on and so forth. And so there's no tension between a true federalist and having a federal definition and yet having state regulation. In terms of why the law should be involved in this, and particularly the federal, is simply this. Same-sex marriage declares to the children of the world that the mother or a father is insignificant or irrelevant, and establishes as national policy fatherless and motherless environments, something the laws abhorred for centuries, particularly in our culture as well. And so that's why the courts need to be involved in a uniform way.
And I think maybe to add to that, the federal government has, of course, been involved in the definition of marriage, most typically in the polygamy case. Every state that was admitted to the Union from the 45th state on was required to affirm that they would not allow polygamous marriage. As a result of the Utah experiment, so Alaska and Hawaii had to affirm, as a part of a condition of their becoming a state in the Union, that they would in fact not permit polygamous marriage. And the Supreme Court endorsed that. And that shows, as my co-arguer here to my left, that the federal courts have a role in defining marriage.
I just want to get clear on what's being argued here, because, of course, in the case of polygamy, what was done to the polygamists was not simply the withholding of legal recognition. People were prosecuted, people were imprisoned, property was confiscated. If this is a matter of such urgency, are you proposing that that be done to same-sex couples?
Well, as I mentioned, there are three things you can do with it. Number one, you can prohibit it. Sometimes we prohibit conduct that has no malum in se. For example, for their own good, you can require that someone wear a seatbelt, even though it may not have a whole lot of spillover effects on society. I don't think there's popular support to regulate it, but that's not the same issue as giving a special preference in the eyes of the law and all the protections of marriage to something that most clearly is not.
I'd like to make a comment. A lot has been said, sort of looking backwards. Marriage has always been like this. Marriage has always been between a man and a woman. And I think it's important to put in context, though many of you may be familiar with it. The institution of marriage has changed enormously. It used to be a viciously patriarchal institution in which the husband virtually owned the wife. Of course there had to be a man and a woman, because if there were no woman, who would occupy the legally inferior position? Women had to occupy that position, right? Now, marriage is legally equal, and there's no reason that it has to be dual-gendered. Marriage has become a much more equal institution. The other point I want to make, I talked about tyranny of the majority. And some of the folks on the right have quite rightly pointed out that there are all kinds of problems with divorce. If you want something that sends a message that fathers don't have to be around, easy access to divorce would seem to send that message. Yet, there's no attempt to amend the Constitution to ban divorce. This seems to me be such a good example of a majority saying, we're not going to limit ourselves in any way, but we're going to limit you. And that's the kind of thing the Constitution is supposed to prevent on a federal level.
In fact, you see a large number of efforts going on in the state legislatures where people are trying to cut back on divorce. You see the covenant marriage movement, you see the marriage movement itself, but what you don't see is activists going in and trying to go through constitutional adjudication rather than the representative legislative process. And again, I note there's litigation going on in 23 states, not legislation going on in 23 states, not going through the representative process, but rather litigation going through to force this on people rather than going through and building popular support. If you're so confident that in fact you're going to win through the will of the people, then put it to the people. But otherwise, then leave it to the people to continue to go forward in the process of dialogue.
Well, this brings me...
But this is why we have... For sure.
This actually raises a question about the respective role of the courts and the legislatures in the area of civil rights on the one hand and marriage on the other, which is sort of the two areas that are implicated by this same-sex marriage debate. So why would it be the province of the legislatures rather than the courts to address these issues? I think this may have been what you were about to discuss. But.
Yeah, I mean, this is a very troubling argument. I mean, it's anti-civil libertarian and it's anti-civil rights and it's anti-constitution, essentially, on so many different levels, because what the end result would be to essentially emasculate any ability of the courts to correct constitutional injustices. It's why we have three branches of government. Often legislatures do react in a way that is tyrannous. Often legislatures in many states are much more conservative as a body than the population generally, and it has always been the role of the courts to be the last vanguard of protection between wholesale trampling over the rights of an unpopular minority and protection. And that's what courts have done here, and it's something we should be lauding and be happy for, because it shows the branches of government each working one against the other. In some states we'll win, in some states we'll lose, but it's great to know that courts are fulfilling their constitutionally and their inspired vision role by the founders in protecting the rights of individuals.
I guess I I'd just remind you that Dred Scott versus Sanford came from the courts, as well as
I'm not saying everything they've done has been great. I mean, you know, we could go on like Korematsu. I mean, we could list a lot of those
Let's
cases.
try Breedlove versus Shuttles, where they upheld poll taxes. It took the 24th Amendment.
Yeah, I understand. They've made mistakes.
Oregon versus Mitchell, where they said that 18-year-olds shouldn't have the right to vote. It also took Minor versus Happenstadt, where they said women didn't have the right to vote. I'll trust the people rather than the courts.
Well, I think we have to be honest and look at this as a real separation of powers problem. I know I represented the state legislature of Florida in Bush v. Gore and Bush v. Palm Beach County, and some of my friends on the left finally discovered judicial activism and how terrible it was. And even though it served the interests of my client in that particular case, the problem is that anyone should see that if 4 people in a black robe in Massachusetts discover through spelunking in some penumbra of the Massachusetts Constitution an evolving paradigm of marriage that they as judicial oligarchs are able to see, even though the great unwashed masses cannot, and give orders to the state legislature to fundamentally alter the arrangements that have been done through the people's elected representatives, that's a problem. Just like if I were on the Supreme Court and determined by cobbling together due process and equal protection grounds that it is a violation of the Constitution to have differing percentages of taxes for different people. We should have a flat tax, and giving Congress and the states 12 months to have a 20% flat tax, people on my left would find a problem with that substantive due process. And this is a very, very real issue that approaches judicial oligarchy in trying to adjudicate very, very sensitive political issues that are resolved better by the people.
I think the lesson of this conversation is that you can't really separate issues of procedure from issues of substance. If there's a fundamental right to same-sex marriage, then the courts should protect it. If there isn't, they shouldn't. So I don't think that we can take the procedural issue, separate out from the substantive object of our disagreement, because the substantive issue will come back in, and we'll just end up talking in circles about either judicial oligarchy or the judiciary neglecting its responsibilities in the poll tax case.
It's a very good point, but as my mentor Archibald Cox said when reviewing Roe v. Wade, they asked him on television where that right came from, and he said, I don't know, I think they just made it up. And the problem is rights can be fabricated by a minority of people who happen to have black robes on, and it raises serious issues.
Well, in terms of the will of the people...
If I might, let me just add,
I'm sorry, I didn't...
if I might, because I might hear Boer versus again. The people have a right to petition the courts, and the legislatures correspondingly have another role. And this issue is erupting in America today, and it's catching up all over the nation. And it is incorrect to prescribe what are the people's rights or the representative votes versus the court. These are all separate and independent tracks set up for deliberative purposes, and a people and a person's access to the court is one of the founding principles of our Constitution. And yes, legislatures are traditionally a little more cautious. They are elected for their jobs. They don't have the protection that the judiciary has. They don't have the protections that they certainly don't have a set of protections that some of us enjoy. So legislatures would be cautious. It would be incorrect to say that avenue isn't being pursued. It is being pursued. It's pursued here in California today, and there's a bill in the legislature today that addresses the very issue, as there are in many state legislatures throughout the country. So there are multiple tracks to petition that are lawful and rightful, and it isn't up to any individual here to opine, because I thought we were going to not have personal anecdotes or what the right of the people to petition the courts are. That's a prerogative in America today, and we hope that people continue to exercise their prerogatives on all the tracks that are allowable in this system of justice.
So let's assume for a moment that one of these bills, let's say it's the Carole Migden same-sex marriage bill, goes through the California legislature successfully. Would you then acquiesce because the will of the people had been expressed, or would you be concerned about the legitimacy of that, or would you seek a statewide referendum or a defensive marriage amendment? How would you respond as a lawyer to that? Or an activist?
Well, the will of the people has already been spoken in the state of California. They voted overwhelmingly for Proposition 22.
But of course, polls show that even Pete Knight, the champion, now supports civil unions as a concept, because the fact is you opened up an avenue, and more people, 36%, 40% now for gay marriage, as is. The whole shebang. So that's fine to freeze in time Pete Knight, and what I tried to do in the beginning to show how rapidly we're changing from even what San Francisco thought was suitable. Right now today in this state, and the Attorney General argument and the Mayor of San Francisco is it is unconstitutional, and that'll be debated by the courts. But meanwhile, even Pete Knight, Senator Pete Knight, the author of Prop 22 that you're all lauding, he capitulated. He'll take civil union rights right now today if they would be accepted.
Well, I'd like an answer to the question.
It's really a hypothetical question. It's not about what has happened, but if that were to happen, what would the response be? Would then the response be, well, that was the will of the people, or what would happen? Would other states be required to respect that under the comity provisions? What would be the next scenario, the next picture, reaction?
Well, I think actually we'll get to find out what Pete Knight thinks on the next panel to start with. And the answer to the question would be, insofar as it is consistent with the California Constitution, I would support it. But just as if the 14th Amendment was violated by the southern state statutes, which persisted in attempting to pass laws after the 14th Amendment was passed, where they tried to reinstitute laws that segregated afterwards, those were illegal, then if the domestic partnership or same-sex marriage law violated the Constitution of California, I would say go back, redraft it, and amend your Constitution to take care of Proposition 22 first. You just didn't do it right, but if that's the will of the people, make sure you do it right, just because that's what good proceduralist lawyers do.
And this brings me to the next question, which was, people travel across state lines and they want consistent treatment as they travel across state lines. And the claim was that domestic partnerships were not sufficient to protect people from this uneven kind of experience. Do you think that domestic partnerships are a good alternative to same-sex marriage? Do they suffer from these limitations of not being recognized in other jurisdictions? What is the role for domestic partnerships with or without same-sex marriage available?
Yeah, well, one comment before I answer that question. We start by saying to people, please don't applaud when we speak and so forth, and whether you're for us or against it. I really like that concept, sort of we're having a discussion, and I just sense emotions getting a little higher, and, let's all go back. I just really liked the whole no applauding, no laughing, and sort of a more dignified discussion. You all do what you want to do, but I just really like that. In terms of domestic partnerships, I'm not a big fan of them. People often will say, what's in a word? What's the difference if they have all legal rights? And I want you to imagine, suppose Jews or Muslims were told, you can have all the same legal rights as Christians, but you can't hold yourself out as a religion. I think we would all sense the limitations of that. Or if interracial couples were told, you can have domestic partnerships, but not marriage. So there's other people on the panel who could do a great job of explaining all the legal deficiencies of domestic partnerships. But I think there's a bigger picture than that. I think only same-sex marriage gives full legal equality to gays and lesbians. And as I've said repeatedly, the Supreme Court has often held marriage is a fundamental right, which means a federal right. And in any event, Congress has already federalized the issue through DOMA. So really, there's no choice but to go through the federal courts.
I grew up in the 60s, believe it or not, and then it was, you know what, we don't need no stinking piece of paper. We just love each other, we're going to live together, right? And now it's gone full circle. Now it's we want marriage. Now why is that? What changed? What changed is essentially a treasure chest is available at the federal level. And so when you're talking about domestic partnerships with civil unions, number one, you're not supporting marriage. You're supporting something else. So it's not going to benefit and confer the communitarian benefits that marriage does. Second of all, on a state level, you're not going to have, quote, equality, quote, to those sorts of relationships. So in any sense of the case, they are a defective, really a dodge of the real legal issues that are out there. Again, marriage, the federal definition is one man, one woman, and for good reason.
I agree with that, and I just want to echo. For people who are not gay or lesbian or have never had that experience, I understand the treasure trove of benefits that are out there and people arguing for and against those things. However, for people who are gay and lesbian or who have been gay and lesbian, I believe that this goes much, much deeper. There is something much more significant about what is being asked for, what is being fought for, and that is for people to be treated the same, to be given the same respect, to be to feel inwardly like they are more than it seems that they have been treated like in the past. And that's not a good reason to change marriage. For me, as I was growing up, homosexual I wanted simply to be treated equally. I wanted to be treated with respect. I wanted to feel better than I did. But I'll be honest, homosexual relationships, acceptance of homosexuality, which is very apparent in our world today, tolerance, which is rampant in our society today, does not change the fact that inwardly there is something awry, that there is something wrong. And marriage, whether it's granted for same-sex people or not, it will never make someone feel better. And there will be just more legislation, endless legislation for people who are seeking...
We're having opinions that I thought we were chided not to do.
Well, we were saying that we didn't want anecdotal evidence, but the fact is, this is my evidence. I'm not speaking for someone else, I'm speaking for myself.
Fine.
I was gay.
You didn't say that, sir. You didn't say you're a tortured gay soul that decided to abandon the community and find a new facet and go on a dog and pony show to advocate a perverse point of view. That's not what you did say, but what you did, what we've been asked here is not to have anecdotes, and you're saying that's precisely what you're doing. You can talk about yourself, sir, and you have quite floridly, but I don't think that's appropriate for you to draw a conclusion about what anyone would desire to feel fulfillment, because you clearly are not an example of that. You're just a recruit for a point of view on a dog and pony show where you came today.
With all due respect, I'm not a recruit. I'm here because I am an American, and I believe that this is an important issue. And I believe that it's very important for gay and lesbian people. And I will be very honest, the majority of gay and lesbian people that I know, and that's a whole lot of people, do not want gay marriage. They simply want to be left alone. This is not good for them, and they know it.
Okay, well,
Nice try,
well, as a proudly, openly practicing lesbian, who has a lot of gay and lesbian friends who are not tortured and who are joyful and happy in who they are, and that's the population that I'd like to speak for. The fight for the right to marry is not so much about needing social acceptance to feel joyful and proud of who we are. That's something most of us overcame a long time ago in a homophobic culture that said we were something less than, and we overcame that to say, actually, that's not true. I am fully who I am, and I have full dignity, and I have the full right to be a human being that is respected by all facets of this culture. The thing about the right to marry, and it's interesting that it would be characterized as a treasure trove by folks who, many of whom I think are married and benefiting from this, quote, treasure trove. The real issue with marriage and wanting to have the right to marry is not just for the, quote, benefits, whatever those might be in terms of financially, tax benefits, or all of those sorts of things. The real issue is the fundamental security, protection, the dignity of the government respecting one's relationship. And there are enormous obligations that also go along with marriage. Child support, spousal support, community property in this state. That 4,000 couples lined up to say, I am willing to assume those obligations for this person who I'm going to share the rest of my life with. That's what we're fundamentally talking about. And polygamy analogy aside, which has come up repeatedly, what I'd like to hear is what is the fundamental objection to excluding from that right to care for each other's welfare with governmental support lesbian and gay couples?
There's a number of responses to that, but let me just say this. I think the view that's been expressed just there is way too narrow. If the issue is committed relationships, people who care for one another, we can do that in a variety of contexts. We can do that. I can take care of my elderly aunt and have economic dependency. I can take care of my brother or my sister who may be disabled. And so we don't call that type of relationship marriage. That's the difference. We can still have fundamental support, security that she's talking about. We don't have to destroy the institution of marriage to do that. So I think we're being too narrow.
But your organization objects to even the most modest domestic partner protections. You attack these bills in every state in which they're introduced. So you actually don't support any kind of protective scheme for lesbian and gay relationships.
That's not true.
Well, I would invite you to go to their website and see for yourself.
Nobody's seeking to trample anything, what is inescapable. It's not about whether your opinion, if this guy converted, if these people think it's okay. It's not about what you think's okay. You know, I've been a legislator a lot of years, 10, 15 years. I don't like everybody. Certainly I don't. They don't like me. That's okay too. You know what I mean? That's a blessing if you like them. But you have work to do together, and you have opportunities. And it isn't about whether they like or approve. Homosexual couples, gay family, been since the beginning of time. We are on the earth. And what I intended to say is, come on, how many of you have been divorced? How many are you not? I see all these rolls of the ones that are clapping, so does anyone want to raise their hand? Nuh-uh, you don't want to tell us that. All right, they're all kind of family. We're on the map today. This is what is in America and the world. So it is not to trample institutions, it's to have the institutions modified to accept new population and new views. We're merely saying we want to be married too. We got kids in school, we pay taxes, we buy houses. We're the victims, not the perpetrators of crime. You think San Francisco is such a liberal haven? They didn't like the influx of people, but 20 years later they say, hey, this ain't half bad. We've got a lot of good people here supporting schools, supporting libraries, supporting bonds, not having children, but being civic-minded, cleaning their house, cleaning the yard, not being afraid, partners. So there are 100 variables you can take, and again, I just say your opinion of what you like and dislike is frankly not what at issue here. But the reality, and as a lawmaker, you know, it's not up for me to divine the world as I'd like it to be. I have to deal with the problems and realities of today. If there's a budget shortfall, there's no money. Should I have done other things? Maybe. But meanwhile, to serve the good people of California, you've got to figure it out now based upon the reality of now, not to pontificate or judge or speculate a better life. This is what is. And in the state of California and all over the nation, we are finding different kinds of American families. And they're being presented, and you know you're the product of them, and it's part of life in your neighborhoods. We're merely saying, without any special rights or polygamous implications or anything else they want to throw, bestiality, I'm surprised didn't come up here. But nevertheless, to say that different family units exist and are so defined in America today all over. And we're saying just simply that you have to make room to modify, to adjust, to legitimize the relationships, the children, to recognize the stake, the stakeholders, and all the other attributes that come with living in harmony with people. You may not make the choices they want. That's fine. That's your personal prerogative. But as the government, I'm not allowed to have that imposition of my personal will. It's my duty and responsibility to find ways to deal with complex problems based upon the reality of what is brought to me today. And that's simply what we're seeking to ask here, and not opinions about if they like it or if the federal government. Let me just finish this, because you keep going with the federal court said and no one else does, as if it was the original Sanskrit for Moses. You know, everything in life is fungible, changeable. You want to know about laws and status and station, all of that's evolving, mercurial. That's the nature of it. So I think there was a good point by the moderator that said, what's the harm? What's the harm if there's an incorporation? And I think that is a legitimate question, and you've asked for no anecdotes, but you've allowed them to voice them ad nominem, ad hominem. And the point is, ad nauseum, the point is, ad
Whatever
nauseam,
ad I did.
beg your pardon. But okay, so you don't like it. We got that. Now, what's to prevent society from making accommodations to all the family units? And if we're going to tag gay families as different, are we going to do that with foster kids or step-parents raising other kids, or the grandparents, or these foreign children that everyone's adopting, or the multi-ethnic households? Is that what's being suggested, that there's some segregation of gay families as opposed to the other kinds of American families emerging?
Well, I think there's another evidence of the is versus ought fallacy. I mean, the fact is, ontologically, there are lots of things There are people who live in all kinds of different relationships, whether incestuous or polygamous, or as long as you want it, maybe bestial. That doesn't mean that because those relationships exist that they ought to be given special privileged status in American law. And the fact is, while one can say that the slippery slope argument doesn't apply because there are too many people, the fact is there's no reason distinction. If you're talking about a person finding authentic sexual experience in another member of the same sex, there's no reason distinction between that person and a bisexual finding his or her authenticity in a bisexual relationship of 3. There's a newspaper article recently of 4 people who decided to live in a committed relationship, 2 lesbians, 2 male homosexuals. There's no reason distinction why one can't say those relationships exist, and sometimes they have children, and if you don't like it, that's tough. We should cloak those kind of relationships with some special legal protection. The fact is, what we have to determine is what is the ought in society, and whether there are very special aspects of monogamous heterosexual unions that should be promoted and encouraged.
Well, there is this way in which they run together that whatever you think, and I think this is one of the reasons why there's as much support as there is for civil unions, which I think that is one thing that's should be clear to everyone about civil unions, is that I think nobody on this dais likes them. They don't like them over there, we don't like them over here, we want marriage, they want no recognition at all. None of the activists on either side like civil unions. The reason why there's pressure for them is because these families exist and there are relationships of dependency, and then you have to decide, well, even if you don't like these relationships, if you have a situation where biological mother dies and her lesbian partner is the one other adult who has raised this child, does it make any sense for the law to make an example of this child in order to vindicate the principle that marriage is just between a man and a woman, if you believe in that principle? And there are even people who are uneasy. This is what the polls seem to tell us, that there are people who are somewhere in between the 2 tables who are uneasy about taking it that far. And so the reason why there is as much political momentum as there is for domestic partnership, which neither side likes, is because the consequences of giving no recognition whatsoever are so harsh that there are lots of people who just can't stomach it.
And now, I just wanted to take the last 15 minutes to go through questions from the audience, and I know Mark has gathered cards. Why don't you come to the podium and read some of the questions out and let the panelists have a chance to answer.
Thank you. Okay, now we're going to enter our audience participation phase of this panel. Thank you all, by the way, for your excellent commentary. Okay, first question, and I'm going to throw it out and see who responds, and we'll take it from there. Given that both religious and non-religious people have a worldview that informs their politics, what do you think is the role of religious beliefs in informing and influencing this debate?
I'll start on that one. If you have same-sex marriage being legal, that would mean that those churches and synagogues and religious institutions that wish to have same-sex ceremonies could do so. They could then marry same-sex couples. Those that did not wish to would not have to. Just the way the Catholic Church doesn't approve of divorce. Divorce is legal, and no one says the Catholic Church has to recognize it. So legalizing same-sex marriage allows pluralism. Those churches that want to recognize it can. Those churches that don't want to recognize it cannot. Making it illegal, the status quo, forces a one-size-fits-all solution in all religions. Right now, no churches can have legally recognized same-sex marriage. So I don't think there's a problem with church and state. If you have same-sex marriage, there'll be marriage for whoever wants it. Whatever churches want to recognize that can. Whichever don't want to, don't have to.
And if
That certainly hasn't been the experience in Western European nations or in Canada. For example, the Cardinal in Madrid recently gave a sermon opposed to same-sex marriage, and he was sued under the hate speech codes. The bishops and priests in Ireland, upon receiving the doctrinal note from the Vatican, was advised by the ACLU in Ireland that they would be prosecuted under that hate speech code. In Canada, a printer who refused to publish some gay pride literature was prosecuted, as was a newspaper publisher, and the person who had placed an ad opposed to same-sex marriage was prosecuted under the criminal statute and forced to pay a criminal fine. So the idea that recognition of same-sex marriage will leave churches safe to pursue their own religious beliefs in this area simply has not proven to be true in England, in Spain, in Canada, and in other Western European nations. In Sweden, they've decided that if you preach on the Bible passages that address same-sex conduct in a traditional fashion, that you have indeed engaged in hate speech and you will be prosecuted under hate speech codes. So I would say quite the contrary. We now see in America that churches do engage in civil same-sex union commitment ceremonies, and there's been no problem with it except an overzealous prosecutor in New York once. Quite the contrary. In Canada, we've seen several prosecutions, and in Europe, we've seen several prosecutions. I'd be more worried the other way to religious liberty.
Well, but these are countries that do not have a First Amendment that has the same kind of religious protections for religious exercise that exist in this country, and I think those analogies aren't particularly apt. I mean, clearly the history of religious practice in this country would, I think, very much strongly support a notion that unwilling churches would not be forced to marry lesbian or gay couples. And as a former ACLU attorney, I mean, I think the ACLU would love to have a case where somebody attempts to make that happen.
They already did. The Georgetown case in Washington, where a local gay rights ordinance was found to trump the First Amendment right of Georgetown to enforce its religious and moral convictions. And in that case, that was an ACLU brought case that had exactly the kind of element of persecution that Professor Collett points out.
But I mean, that's red herring. I mean, that is just a completely different issue. I mean, what you're talking about is these are the classic non-discrimination ordinance that says, for example, you can't discriminate in housing. And in public housing run by a church, for-profit or even not-for-profit, they exclude lesbian or gay couples, or they exclude unmarried couples, and that's not permitted if they're going to be on the open market because there's a non-discrimination ordinance that trumps. If that church wants to make that completely private, they're able to do so. Clearly, we are going to have to, in a multicultural nation, have some sort of balancing. And there have been times where a non-discrimination ordinance that says you can't discriminate against these people in these business practices and accommodations on these categories does, in fact, trump a religious institution when it meanders out into the public realm and attempts to be making money or working on the market. That is when that ordinance comes into play. But what I'm talking about and what we're talking about around unwilling churches being forced to marry lesbian and gay couples, there's just no specter that that's possible.
Well,
if I may briefly
as a matter of fact, with all due respect to my colleague, she's got the wrong case, because Georgetown did not have to do with public housing, but the organization of a gay rights group
I know, I was
on
just making
campus.
an
That was the
analogy.
yeshiva case I think you're thinking about. In any case, the fact is that one can see down the line an attempt to pull tax exemptions of religious organizations for, quote, discrimination, if in fact the analogy, which I find very offensive, of sexual behaviors to people who came over here in chains and couldn't drink out of white men's drinking fountains, if that analogy holds, then one can easily see efforts by the IRS or public bodies to pull tax exemptions for people exercising their freedom of religious conscience. And I think persecution of that kind is a very real possibility.
Yeah, I just can't agree with the idea that churches would somehow be prosecuted for discrimination. Let me just give you an analogy. The rabbi who married me and my wife refused to marry her brother because he was marrying a non-Jewish woman, a Latina Catholic. Now, religious discrimination is illegal in this country, but I can assure you my rabbi did not worry that he was going to be prosecuted for religious discrimination because he has the full protection of the First Amendment. And we were talking about anecdotes, but I mean a small number of anecdotes cannot change the fact that ministers and rabbis marry whoever they want. They don't worry about whether they'll be prosecuted for religious discrimination. And these small number of anecdotes can make me think that churches will be bullied into recognizing, the Catholic Church will be forced into recognizing same-sex marriage. I think that's very, very speculative and incredibly unlikely.
I think it's important not to unnecessarily raise the stakes. They're already pretty high. I would happily exempt religious organizations and even religious universities from anti-discrimination laws if that's the price of getting same-sex marriage, and you would never accept that deal. So,
we have time for one last question. Was the legal route chosen by San Francisco recently the most advantageous to reach the goal of a court decision permitting gay marriage? If not, why do you think Mayor Newsom chose the route he did?
Well, Barney Frank certainly didn't think so.
I think that Mayor Newsom's chief of staff called me on February 6th and said, the afternoon of February 6th, just to shorten the time as much as possible, and said, I just want to let you know that Mayor Newsom is going to begin issuing marriage licenses to lesbian and gay couples Monday morning, which was the first I'd heard of it, and I was the first person to hear of it, other than the mayor's staff. I do think that the mayor's step was spectacularly bold. And I think that history will show that it was the right step at the right time, even though it feels there's been an enormous, in many ways, politically motivated backlash. But I do think that there's been an enormous outpouring of support, and it's incited an amazing dialogue in this country. There will always be a third of this country who we're never going to get on the issue of equal marriage rights for lesbian and gay couples. I mean, there's still a good third of the country that's, I'm sure, avowedly racist still to this day. There's a third of and I'm not saying they're the same, so just, there might be a Venn diagram, I'm not saying they're the same. There's a third of this country that is 100% for embracing equal marriage rights for lesbian and gay couples for a whole host of reasons. And then there's the third middle. And it's that middle that I think was moved by the images in San Francisco. It's that middle that most of us know. It's that middle that are most of our families. And it's that middle that are changing their hearts and minds. And the numbers show, poll after poll, shows that these numbers are changing in terms of support for lesbian and gay relationships. So while I do think the mayor's action was unprecedented, at least in modern time, for an elected official to do this, and provocative at some level, I do think that this case that is now proceeding in the California courts is an amazingly strong case with an enormous variety of couples who've been together for various years, and I do think that now that California would be the 5th state Supreme Court to hear this case, it will be the right case at the right time, and the mayor's action and what happened will be something that we will look back on and celebrate.
This poll shows the mayor's constituents, 66% in San Francisco today, support his actions.
Well, let's let the people decide then, and not judicial oligarchs who feel the right to invent rights out of whole cloth.
Well, as we said, you got the right to petition the courts, don't you? I mean, aren't we fighting in Iraq for a free government? Don't the people have the right to petition the courts? I mean, there again is another one of your opinions. I thought we were trying to tuck those in a little bit. You don't like the courts, that's your right, sir, but that is legally germane and in order for anyone and any citizen. We're losing. Look at what's going on as the Senate debate to re-elect the president. It has to do with fundamental liberties. So why is it, Madam Moderator, that these folks interject that all the time and we're not kicking them out for it?
I think that
Madam Professor.
what if the judicial oligarchy here, when whatever you think of the mayor of San Francisco, he's not an unelected judge. He's an elected official. He's doing this because he thinks it's going to help him get reelected. He's acting like a politician.
Maybe what he thinks is the right thing to do. Maybe what
Yeah,
doesn't.
I'm not sure that this helped his political career in the long term, but I do think that he really is a true believer, and I do think that he believes that this discrimination is fundamentally wrong and that he wanted to take steps to correct it. And it's the kind of political courage that we don't see very often in this country anymore, and it was inspiring to see.
I think that we have to be careful, though. Obviously, I don't support same-sex marriage. It's not because I'm a member of the Flat Earth Society. I don't think it can be justified philosophically or legally. But when you have a mayor of a city, what if a mayor of a city said, you know what, our state constitution proscribes discrimination against the disabled and against youth, against age, so I'm going to issue pilot's licenses to 10-year-old blind people. Would we applaud that with the same rhetoric? I would hope not. There's a huge issue in terms of how one discharges their office, aside from the issue of same-sex marriage. And that, I think, is what rumpled a lot of feathers and so forth, is because that's not how these issues ought to be dealt with. They should be dealt with. If you're going to litigate it, don't just issue things.
I got to respond to that analogy. Obviously, what you're talking about would cause death and destruction on a massive level. I mean,
How do you know the other won't?
Let me finish my point, please.
How do you know
Let
the
me
other
finish
won't?
my point without interruption, please. There's a huge problem with that analogy. I mean, the big difference is, and the reason the courts were slow to step in, is no one is harmed by same-sex marriage. Nothing radical will happen. A small group of people who've been excluded from marriage will now be able to marry. And that's why I attack the notion of natural and so forth. All the arguments against same-sex marriage are incredibly speculative. Frankly, I was thrilled with what the mayor did. It's always bothered me when people forbid gays and lesbians from getting married and then chide them for promiscuity. It's never made sense to me. And it seems to me that it was very important for people to be exposed to this counter-image, this image of lesbian and gay people as loving, mature people who want to commit to the person that they love. He rendered something that had been forced invisible and made it visible. And I think that was a great and beautiful thing.
Here again, I think it's impossible to separate out issues of substance from procedure. I think that if some registrar of marriage in Virginia in 1966 had started defying state law and issuing marriage licenses to interracial couples, each one of you would have applauded that. So it's not possible to separate it depends on your views of the substance.
I think one of the questions, though,
procedural issue is a sideshow.
I would encourage people to evaluate this harm claim. Just because harm's more immediate in my analogy doesn't mean it doesn't exist in issuing same-sex marriage license. In fact, PhD Joseph Unwin in 1935, having looked at various cultures that dealt with sexual behaviors, indicated that the harm ultimately comes to roost when people abandon absolute monogamy 35 to 40 years later. So we can't just say, well, I don't see it tomorrow, therefore there's no harm. That's
Well, I think
fallacious.
you should talk to your own people about that.
Okay, now we're going to have to stop now. Well, the time has flown by. I thought it was a truly riveting and provocative discussion, and I think you probably agree. I wanted to have a round of applause for all of our panelists.